Okay, we're gonna get started here. Everyone could please be seated. There is a sign-in sheet in the back. If you would please sign in, we would appreciate it very much. Also, we are recording, and it's being recorded just so it helps with the minutes, just so everybody knows. So we'll get started. 7:30, we have a public hearing, reasonable accommodation to modify the approved site plan for a detox facility at 362 Middlesex Ave. Bettering LLC, you're up.
Good evening, Mr. Chairman. My name is Mark Bobrowski. I represent Bettering LLC. My office is in Concord. Thanks to you and the board this evening for taking up our request for a reasonable accommodation. This matter, as you know, was the subject of a special permit application to the Board of Appeals about a year and a half ago. We subsequently found ourselves in federal district court when the matter was removed there, working with Magistrate Judge Bohl, who convened a mediation. We talked our way through most of the issues, and we find ourselves back here on a joint request for a remand to the U.S. District Court. I'm going to turn this over to Ben Osgood, who will walk you through the changes to the site plan since you approved the site plan back in 2018, and Ben will take you by the hand and show you what he's done.
Okay.
You want to take this over?
Good evening, Ben Osgood, engineer with Ranger Engineering Group. So, we all know where the site is, the Middlesex Ave, right by the railroad tracks. Railroad tracks are on the right side of the plan, which is north. We have the residential neighborhoods that are south and west. Middlesex is down on the east. The site previously had a small cul-de-sac bulb, and the building was back closer to the rear property line. This particular layout has a typical driveway for the single building. It enters off of Middlesex Street. Circulation is around the building, 22-foot wide access roadways. Parking, we have 59 parking spaces where 48 is required for this facility. It is mainly along the front. Up in the back, there's some another row of parking, and then on the west side, there's additional spaces. All of these service entrances are towards the back on the west. That is a loading zone. The dumpster is kind of at the top right, pretty much the same as where it was before, as far away from the residential properties as we could get it. There's a row of trees between the residential properties and the development. The septic system is essentially in the same location up on the west side of the property. However, we have redesigned it. It's a different type of system, so it essentially takes half the area as we had before. We have a primary and then a reserve area, which results in us having to clear less land up on that northwest corner. We are still proposing the trees and the fence in that location, but there'll be less clearing.
There's no wall in the back, right?
There is a small wall. It's only 3 feet high, runs about 150 feet along the back there, just in the low spot. But the wall is set back from the property line 6 feet, and the buffer screening trees would go between the property line and the wall. Okay. And then the fence would go above the wall. Obviously, it's still municipal water. The septic system is in the back. The stormwater system essentially remains in the same location. Buried stormwater system under the parking lot. So the catch basins flow into the stormwater system, which provides treatment and retention, a large amount of infiltration, and so we meet all the stormwater management regulations. We exceed, in the smaller storms, we exceed the stormwater management regulations. There is a small pond down on the front left that basically receives a small amount of water and controls runoff through infiltration primarily. That's, I think,
What's
Yeah.
the width of the driveway opening?
the driveway opening's 24 feet, it's a standard width.
Fire truck makes the loop.
Yes, we have fire department turning plans that are in the plan set, and I believe they've been approved. We also have the WB 50 truck, delivery truck, and that can maneuver through the site as well.
Snow storage.
Snow storage is outlined on the plan. It's essentially in the same locations it was before, along the edge of the parking lot, in dedicated areas. So, that's essentially all I have.
Architecturally,
So architecturally, these are the revised architectural plans. They've added a different roof treatment. Before it was a flat roof, as you remember, so now we have different architectural siding. I think there's a stone, I guess they call it an apron around the bottom. They have the, kind of a, I think it'd be a hardy plank siding on the first floor, up in the end peak here, and then, I guess just the solid panels up on the top. It looks like a standing seam roof. The entrance has been moved more towards the roadway to give it a little more street presence. Previously, the entrance was up here, now it's down in here. There's a stairway, sidewalks leading out to the sidewalks on Middlesex Ave.
height of the building,
Height of the building.
it's a change from last time.
It is, I believe, a little bit taller because of the peak roof, but it does comply with the zoning regulations. I believe it's 33 feet total.
Max building height is 35 feet,
Right.
3 stories.
Right.
It's provided, it doesn't say.
It's 33, 2 stories. It's on, I believe, some of the architectural details that are in the set, but I didn't put them on the board.
Okay. Does the board get any questions?
I only have concern with one of the snow storage areas you have. It's right up in the front of the property. I think it would be better back on the curved road over the reserve area, only because that could affect sightlines on 62, which is always difficult to see. The one in the front right there.
Right in here, right.
I think it'd be better on the back curve there, because you won't affect parking.
That's actually, that's a depression, so I know we designed them to
They
take
still
snow and
get pretty
treat.
high.
Right.
Just go to Demoulas here in Carolina, Market Basket, you can see
Yep.
pretty much, a lot of snow storage, and we haven't had that much snow this year.
So you didn't increase the green space at all, right? It's pretty much the same.
I believe it increased a little bit, but it's about the same.
Okay. Okay.
The patio areas,
Yes.
so one's enclosed and one's not, can you talk about the difference? between-
They are both enclosed. They would,
Okay.
they would both be, yeah, there's stockade fences, and they're
Oh,
both,
yeah, I see.
yeah, there's
Okay,
two
not labeled.
columns.
Good, good, good. So engineering-wise, is the access in and out a little bit better?
It's about the same. I mean, it's not a cul-de-sac, so it's definitely not as much pavement, but it does have adequate sight distance in each direction. It's in the perfect location on the curve. It's, adequate width for the fire trucks and vehicle access. The driveway on the bottom side would be one way, so you would enter and just drive straight, and then you could only come out the driveway on the south side of the building there. And there'd be signage indicating that that was do not enter.
Any comments from engineering?
We did have some comments from February 24th, and that's from both engineering and planning. If you want to read those, they have revised the plans to address those comments, so no outstanding
So there's no outstanding.
comments. The one comment from engineering was just to, a supplemental hydrological computation was submitted, and to have that be compiled into a full stormwater report to be resubmitted, just because it was 2 pieces. So that was the only outstanding comment from engineering.
Okay. Anything else?
I'm all set.
Mark, anything from you?
Just in conclusion, Mr. Chairman, this is a reasonable accommodation that we seek under the Americans with Disabilities Act and the Federal Fair Housing Act amendments of 1988. Both laws are designed to protect people with disabilities. Recovering drug and alcohol addicts are such persons under federal law. The nature of the reasonable accommodations, just to be precise, would be an accommodation to override the prohibition on hospital and nursing home in the GB district. You'll recall that was changed at the 2017 December town meeting when we made our initial approach to the town. And I believe the only relief that we would need otherwise is the frontage. Were we 12 feet short, Ben? 12 feet short of frontage is the only other reasonable accommodation that we seek. I think it's a better plan. We know that the ZBA process made it a better plan because some of these ideas came from one of the members of the ZBA in terms of making the building more attractive and compatible with the neighborhood. Lastly, there are 15 conditions that we've agreed to in the remand order. I don't know that the board needs to concern itself with them. We're before the ZBA on next Thursday evening. They'll be certainly imposing those conditions, I'm sure, if they go forward with an accommodation. And lastly, we would ask that as a condition of an accommodation, that these 2 plan sets that Ben has just explained be incorporated as the plans of record with a change as suggested, which we're agreeable to. Thank you.
Thank you.
He brought up the look of the building, which I know was part of the ZBA discussion. What we do doesn't actually hold that, right? But does the ZBA hold that? Like, can they make sure that it looks like that when it's, you know, kind of built, like it's not going to change? We're kind of looking at the site plan, the ground.
We've submitted the same plan sets to the ZBA.
Okay, I just want to make sure that that's,
Identical.
that doesn't go away, you know?
Nope,
To
identical
this, yeah.
plans.
Okay. We'll open it up to the audience. But be a few rules here. 1, you have to state your name and your address, speak clearly, and one at a time. Address the chairman, and let's try not to be repetitive and keep things moving. So who'd like to go first? You're up.
Thanks, Mr. Chairman. I'm Kevin Brander. I live at 5 Catherine Avenue, and I want to address some of the things that were said by Attorney Bobrowski. He's represented that his client is due reasonable accommodation under the terms and conditions of the Americans with Disabilities Act and the Fair Housing Act. I've submitted a letter to the board and to the town council, which I hope you have before you, which has basically cites numerous incidents of case law where the matter of reasonable accommodation has been front and center, has been a core element of those court decisions. In those cases, the findings were very conclusive that current drug users are not covered and afforded the protections under the ADA or the FHA. I've asked through the chairman that be directed to town council for his opinion on that. So I would ask if you have done that or are going to do that.
That's a good question. Say that again? I gotta think about that.
I'm asking
You
the board,
Are you asking if I, as town council,
I'm asking you to direct town council to provide direct input on this matter of if the applicant has standing under the ADA and the FHA to even request such a reasonable accommodation.
council?
Thank you, Mr. Chairman. Jonathan Silverstein, Town Council. And I'll just note that in the federal court litigation, the town is being represented by Insurance Counsel, which is the law firm of Brody, Hardoon, Perkins, and Keston. Jeremy Silverfine from that firm is here as well and can answer any questions. Since they're defending these discrimination claims, some of this may be more appropriate coming from them, but I can certainly address the specific question. The case law cited in the letter forwarded earlier, and I did see that letter previously as well, and did provide confidential advice on the matter at the time. That case law deals with a separate section of the ADA. It deals with a section referred to as the safe harbor provision with respect to employment discrimination claims. It does not apply in the context of a land use regulation, and there are a number of cases throughout the country that hold that this type of facility that treats people suffering with drug and alcohol addiction are entitled to the protections of the statutes. So I don't know if Mr. Silverfine wants to add to that. I do want to say I need to be a little bit careful because there's still pending litigation. So I think both Mr. Silverfine and I are probably going to want to be a little bit careful, because if the litigation is not resolved, we don't want to expose the town to more liability than it may otherwise be exposed to. So I just want to say that as a threshold matter.
Okay, thank you.
Well, I would still respectfully disagree with that. I think if this were a sober house or a group home, those protections are obviously in place. And, you know, I think we got sort of a half answer, but I would still maintain that this reasonable accommodation request is not supported. Thank you.
Thank you. Come on up.
Hi, Christine Prendergast, 7 Pinewood Road. I just wanted to clarify, make sure I understood.
Easy, she can't keep up with you.
Oh, sorry. Wanted to make sure I understood what was being asked. Under the FHA and ADA, are you requesting override of this being designated as a nursing home, as was initially asked? Is that what is being asked? No. Okay. So could I have clarification on that? Because I couldn't hear that well back there.
Are you asking why they're back? Is that what you're asking?
No. What I thought I heard was a request to override that initial filing. So I want to make sure, because I want to understand the septic as it relates to a nursing home and whether or not that's applicable or what it would be filed as.
What is it filed as? Haven't we gone over this?
When we initially applied in the 2017-2018 period, a hospital and nursing home was allowed by special permit in the GB district. The applicant froze rights under the existing zoning bylaw prior to that vote of town meeting and preserved for itself the right to apply for that by special permit, which we did at the Zoning Board of Appeals. With this accommodation request, we're skipping that. We're just simply asking for an accommodation over the classification of hospital or nursing home. We're not seeking a special permit for that anymore. We're not seeking subdivision approval in order to vest those rights. That's the closest category that you have in your zoning to what we're proposing to do. As to whether the septic system has been sized for that, I'll leave that to Mr. Osgood.
The use is a broad use as defined in the zoning bylaw. Our specific use is based on the number of bedrooms. It's a certain amount of gallons per bedroom. We have 48 bedrooms, and I think we come up to 7,900 gallons per day. to service the facility that's proposed, and that's what the septic system is designed to do.
Septic system went through the Board of Health?
It was previously approved, but we've redesigned it, different type of system to make the area smaller, and we're going through that approval now.
Okay, so if we want to challenge that, based on EPA recommendations, that quote-unquote commercial establishments such as restaurants, nursing homes, hospitals, and other public use areas do not generally use septic tank systems due to oil and grease, odor, and flow issues. How do we do that?
Not for me to say.
So it's definitely a voting question.
That would be something you'd take up with the Board of Health.
Okay, so we have
Remember,
researched.
I'm sorry, I
Yeah.
didn't interrupt you. You have
It's
a
okay.
chance again. I didn't give my typical speech. We're reviewing the site plan review, just
Mm-hmm.
the site plan geometry and how things flow.
Mm-hmm.
Okay?
Yeah,
It's in traffic.
right. That's why I'm asking, because I understand that septic is not your purview.
That's correct.
So that's why I'm asking, how do we challenge that?
You would have to go to the Board of Health.
Good.
Mark?
Good evening, Suzanne Sullivan, 60 Lawrence Street. So I have quite a few questions because this is quite the process. But one of my questions is, according to this, to the hearing notice, it says reasonable accommodation to modify the approved site plan. The approved site plan, does that even exist anymore? That had the cul-de-sac on it, and the cul-de-sac to which also grandfathered, so-called grandfathered the use, which no longer exists because they actually closed their case in Superior Court. So there is actually no existing plan. Is that correct? Officially?
Why would it change?
When they came in here before, they had a cul-de-sac. The cul-de-sac was there supposedly to grandfather the project. There was a whole public process.
No, they were
This-
going through the public process, they submitted, and then after, it was decided by people in the town to put something before the town meeting to change the zoning, right? So during the process, they had submitted, locked in, it was reviewed, it was approved. Nothing, that didn't change. It was legalities, it went to court,
No,
and it's come back.
the so-called approved plan no longer exists because it was appealed. The subdivision plan was appealed, so it was never filed. There is no approved plan. That plan is still under appeal by the citizens. The subdivision plan never went forward. So there is no approved plan.
You, as a planning board, you approved two plans back years ago. One was a site plan, that was not appealed. The other was a subdivision plan, that was appealed.
Right.
We had a conference with Judge Rubin 2 weeks ago. She asked what was going on with the case. We explained to her that we would be coming here tonight into the Zoning Board of Appeals on the 18th. We told her that if the reasonable accommodations were granted, it would moot the subdivision appeal because we no longer would need the subdivision plan to vest our rights under the old zoning. She understood. She stayed everything until these two meetings are concluded here in the town. That subdivision plan is still alive. It's just on a stay at the land court right now.
Okay, thank you, that's great, that's the clarification that I wanted. So that plan, the so-called approved plan, had a subdivision on it, totally different septic system, and they're asking to come in to modify that plan. Anybody can look up what the word modify means, and the word modify means to change something in a small manner, in a small way. This is a major change. No more cul-de-sac, They don't even meet zoning. And that's my other question, is I'd like to know what jurisdiction that this board has to waive zoning. My understanding of site plan review is to help an applicant to come into compliance with zoning. And, and I can refer to section, under procedures, section 3.4 of the bylaws of site plan review. And it says one of the provisions is F, compliance with all requirements of the zoning bylaw. Their grandfather status is highly questionable because that original zoning, the original site plan, I'm sorry, not the site plan, the original subdivision control plan has been appealed. And they probably don't meet zoning. That's why they're coming to this conclusion, is that they don't have a leg to stand on when they submitted a one-lot subdivision. So now they're coming in and they want to come in under so-called accommodation. And it's called reasonable accommodation. Reasonable accommodation means that it's reasonable. Ignoring the underlying zoning is not a reasonable accommodation, it's an unreasonable accommodation. And even in the judge's assertion when they came forward, that was the other thing, this was not remanded back here. The remand that they filed didn't work, and the judge said that it couldn't be remanded, but the judge would stay the process. And even the judge notes in his decision that this is a prohibited use under the zoning. And that's the judge's words, prohibited use. And this board is reviewing this case and are going to allow it to go forward, and it's prohibited. And I don't think
Hang
you
on
have
a
the right to
second.
do that.
The board's reviewing what case? When you say case, what do you mean?
This case here, the whole case.
We're reviewing.
The site
we're
plan
reviewing-
review.
We're reviewing a plan, we're not reviewing a case.
All right, site
We're not-
plan review.
We're not the lawyers.
Well, site plan review, I stand corrected.
Okay. I just
Okay?
wanted to be clear.
So you're going to approve a site plan that does not comply with the zoning bylaws. You can do that. You have the authority to do that.
We have the authority to give a waiver if that's what we feel that we need to do. We think if we feel that this is a better plan as far as access in and out of the facility, yeah, we have a right to do that.
No, yes, you can waive certain things, but you can't waive the bylaw. It's not your jurisdiction to do so.
What bylaw are we waiving?
It's a prohibited use in that district. They no longer have a subdivision. The subdivision is what grandfathered this lot. That's gone under this plan. There is no more subdivision on this plan. They're no longer grandfathered. They closed that case in Superior Court. It's done. The appeal. They're holding on to the subdivision in the citizen court, but they're before you today with no subdivision. The subdivision is what grandfathered this case. This is a prohibited use under that zone. And they're asking you to come in and give a reasonable accommodation. It's not reasonable to ignore the bylaws. A reasonable accommodation is if you need a ramp, if you need a setback. That's what they're asking you to do. I think everybody knows that too. I'm just coming up and saying it, but I think we know it. And I take issue with that. Because, we all know that we all take an oath to uphold the bylaws of the town. Before anything. And that's all we've ever asked, is we want the bylaws upheld in this town. That's it. If somebody has a right to build a project, they have a right to build a project. They don't necessarily have a right to build a project here. It was always a special permit. It was never a right by use. They screwed up on their subdivision plan. They're in court. They dropped the appeal for the zoning board of appeals. That's a done deal. That's a closed case in Superior Court, and they went right to the feds. It's closed. We did our homework.
That couldn't possibly be more untrue, Mr. Chairman. The matter was removed to the federal district court by 10 counts. The land court case, or the Superior Court case, I think I filed it in Superior Court case, is still there as to the state causes of action. That hasn't gone away. The subdivision plan is still alive in the land court that the neighbors filed an appeal of. The federal district court took jurisdiction over the federal questions that are involved here, and we had a mediation reasonable accommodations, that's exactly what a reasonable accommodation is supposed to do. It waives zoning requirements to the extent that such requests are reasonable. There's no blanket prohibition on a waiver of zoning, otherwise there would be no accommodation. In court, the fact is that the court has said on several occasions that waiver of zoning prohibitions and bylaws is, in fact, consistent with the notion of a reasonable accommodation. So that's what we are here to seek from you this evening.
And I would agree that there's provisions in the law that you can make a request to change the zoning. Not to change the underlying zoning, but to give variances to the bylaws. And that's basically what a reasonable accommodation is. It's a variance. It's a different name, but it's basically the same thing. It's a variance. But it does not, and there is no case at all that shows that you can go in and just ignore the underlying zoning and put a brand new building there. There's not one case. And I would like to have council point out to a case, and that will be the end of it. Just point to a case where there's ever been a situation in the whole entire country where zoning has been ignored and a whole new building is put up for a detox or any medical facility, because that's what this is. If FHA doesn't apply either, because it's not housing, it's not a dwelling, it's a medical facility. And if you go to the court case is closed. That's what it says, closed. I don't know what else to say. It's closed. I mean, you know, we did it. I'm sure somebody has a copy of it. So once again, I still don't understand where the jurisdiction of this board lies. I can see the ZBA, but not here. The ZBA has a jurisdiction to waive bylaws and setbacks, but not this board. Thank you.
Thank you.
My name's Janice Sawyer. I live at 58 Lawrence Street. And first of all, I'd like to just ask, the Zoning Board of Appeals some time ago took a vote to decide whether or not they should even entertain a reasonable accommodation. And they voted no. They said that they weren't even the proper board. So I'm curious why it's falling onto you to consider a reasonable accommodation. Will you be taking a vote to determine whether or not it's appropriate for you to even do that? Or have you been told by some other person or body that you are going to? You know, and if so, then who is that? You know, is it a fact that it's even your job to even entertain a reasonable accommodation? That would be the first thing to me. The first order of business would be, you know, the Zoning Board of Appeals took the vote and said, no, that's not what we should be doing. We're not the body to do that. So that would be my first question.
Because of that vote is the reason we're here.
So you're saying that you agree and are going to move forward, that each one of you believe that it's your job, each member on this voting board believes that that's what you should do, that it's your job here in town
It's our
to
job,
entertain a reasonable accommodation.
it's our job to review that plan as it was presented.
Well, it says on the agenda that you are entertaining a reasonable accommodation.
Correct.
Not that you're just looking at a site plan.
The reasonable accommodation is this revised site plan. Correct?
So you don't
If I
feel,
misspoke, someone correct me.
so you don't
so-
feel as though you need to take a vote of whether or not it's your job to
No,
entertain a reasonable accommodation.
no.
Every one of you agrees with that, okay?
It's not the reasonable accommodation, it is the site plan that they're requesting be approved towards the reasonable accommodation. We're not voting on the reasonable
Reasonable
accommodation.
accommodation.
Item 6, the draft decision for the reasonable accommodation is not something you're voting on tonight. The draft decision, which I am quite angry that, you know, isn't available for us to see, that I had requested yesterday by email, today by email, yesterday at the Board of Selectmen's meeting, you know, so that we would have some idea of what kind of questions we wanted to ask. But it does say here that you're voting, that you are considering a reasonable accommodation. That's what you're voting on.
Through you, Mr. Chairman. So any vote that this board takes tonight, the purpose of this board looking at the revised plan is because you had previously approved a site plan, and that site plan is changing. Any vote you take is going to be subject to whether or not the Zoning Board of Appeals approves the underlying accommodation request by the applicant on the frontage and use issues. So the reason, I don't want to speak for the applicant, Mr. Bobrowski can speak to why he phrased the modification request as a reasonable accommodation, but I think it's because it was in recognition of the fact that it's all going to hinge on whether or not the Zoning Board of Appeals grants a reasonable accommodation, and there is that provision in the site plan section of your bylaw that requires zoning compliance. And so if this board votes to approve this modified site plan in the form of an accommodation as requested by the applicant, but the Zoning Board of Appeals were to vote no, then the site plan couldn't go forward as modified. So that is why, I assume, and Mr. Bobrowski, you may want to correct me as to why he phrased it as an accommodation request. Just to Ms. Sullivan's point on why the Superior Court case is closed, and again, I'm not counsel for the town in that case, but just being familiar generally with when cases get removed from state court to federal court by a defendant. So here it was Mr. Silverfein's firm removed the case that Mr. Bobrowski filed in state superior court. There's a provision in federal law that says if the claims involve federal questions, then the defendant, in this case the town, has the right to remove that case to federal court. When a case gets removed to federal court, the superior court closes it because they like to be able to check the box that administratively they don't have this open case. Oftentimes, after federal claims get resolved in federal court, the case may be remanded to state court. If that were to happen, the superior court would reopen its file, and the superior court, the state claims would be resolved in state court. But that's why the docket would show that it's closed.
Or it's closed.
Well,
Or it's closed.
but there hasn't been a substantive determination. So it's not closed substantively, it's closed administratively because it's sent to federal court.
Well, I would just like to, I mean, I did have on my paper to also talk about the same thing that Suzanne Sullivan did, and I would have to agree with her. This is not a modified plan. This is a brand-new plan with a brand-new design, brand-new building, new frontage, new different septic system, the whole 9 yards. You know, and again, whether or not the septic system qualifies because it didn't before. But, you know, and it's unfortunate that the public meeting is being held here because I realize you can't answer some of the questions, but one of the big questions I've had is, you know, they're saying this is the best reasonable accommodation that we could come up with. And we've asked, and I'd be really curious, and I know that Mr. Hull would know, was a land deal ever offered? Was a land trade ever offered as a reasonable accommodation, as opposed to having this building built in an inappropriate site and having to waive all of bylaws to do it? I mean, I know we have both lawyers here, Mr. Hull here.
That's not why we're here.
I know, rather conveniently. rather conveniently. Yeah,
We're the planning board.
right. I mean, and I pretty much
Good
said it was
question you can
designed to
take
be
up.
that way.
In a different meeting. I didn't have it
That's all for now.
on. So I'm having a hard time with one thing here, maybe it needs to be a little clarified. I don't see how we're just throwing away all the zoning. I mean, we're accommodating the height, we're accommodating the parking, we're accommodating setbacks, the green, so what specific are we throwing out that is of the zoning? What are we throwing out that I'm not seeing? They're grandfathered in. Slow down. Prohibited use,
It's prohibited use.
but it's not a prohibited use.
Yes, it is. Can you please explain why?
It became a prohibited use, Mr. Chairman, when town meeting changed the zoning in 2017 deliberately to sabotage the application for
Right.
this proposal, proving the discriminatory intent of the town at that time.
Mr. Nealon didn't even own the property before the first public notice was put out that the bylaws were gonna change. He didn't even own the property, he purchased it after.
That is not unusual. Anyone else? Do two more after this, okay? I was waving him, I'm sorry, ma'am. He was,
Rob
he
Fasulo,
was
28.
first.
Rob Fasulo, 28 Marjorie Road. I guess that you just kind of answered my first question. Does this actually meet zoning? How does it fit?
The one zoning requirement, I think it was actually mentioned in the presentation, is that they're short on frontage. I think they said by 13 feet.
Okay, what about use? Does that fit?
That's a more complicated question that currently it does not. Currently, the use is prohibited, but they did vest their rights by going through the process. That's,
All right, well, that's neither here nor there. I'm going to quote from...
Quiet, let's go, let him speak.
I want to quote from the Public Law Journal with regards to FHA and whether you guys have to approve this. If you'd give me a little leeway.
I'll let you do that, but, you know, we're not lawyer, well, I shouldn't say that, he's a lawyer.
All right, well, I'll give you, you're welcome to go look at it.
I
I actually
understand.
posted it on the internet.
This is not the, this is
And
not.
if it requires a fundamental alteration of the town zoning, you do not have to approve it. I think this is a fundamental alteration for zoning. And the second thing is
Because of the use.
because of the use, we
Okay,
just
okay,
said.
that's, I just.
The second thing is, I wonder if anybody else, if I came in front of you with a plan that didn't meet zoning, would you guys actually let me go through this process?
Depending on what it was.
Enough said. Thank you.
Anthony Saragossa, 25 Marshall Road. A couple minutes ago, the attorney stated that at the town meeting, we changed the zoning specifically for this project, which is absolutely not true. It was discussed in depth before, during the meeting, and after, that this had to do with just future projects as well, so it was not specifically for this. It may have seemed like it, and maybe that might have been the primary reason at the time, but it was discussed in depth by several people that this has to do with any future projects going forward. So it was not specifically for this project.
Okay.
That change in town
Thank you.
zoning at town meeting.
Miss, did you want to speak? You're gonna be last.
I'm Kelly Richards. I live at 31 Shady Lane Drive. Is there a way to make this taller? Please?
Terry,
I'll pull it out. Whoops. Suzanne. Well, while I wait for her password, under normal circumstances, if a site plan came forward here to this board for a building in a zone where it was not zoned for, what would you do?
I wouldn't get that far.
Okay. Right. Okay. Next, from the federal judge Saylor, it says, this lawsuit arises out of the planned construction of an addiction treatment center. The complaint alleges that plaintiff Bettering LLC bought a property in Wilmington on which it plans to operate an addiction treatment center facility. Because local zoning bylaws prohibited the construction of the facility, Bettering applied to the Zoning Board of Appeals in Wilmington for special permit or reasonable accommodation, which were denied.
So the judge says it.
The judge says it, because the use is not permitted in the zoning. Lastly, I'd like to know if the building inspector will issue a building permit for a building where the use does not meet zoning.
Well,
Okay. And one more thing, this is obviously very unusual, right? I feel like when you all come to your meetings normally, you come with a sense of confidence and purpose, and you understand your role. And in this certain situation, well, you're looking around and looking for
Well,
what's the answer, what do we do, what do we do?
there
It's
is
not
an
inspiring
ongoing-
confidence
excuse me, there's
in the public.
an ongoing lawsuit. We have to be careful of what we say and do not say, so.
Okay, so
So
back
we
to the
can't just
bill-
say, I mean, we have to go back to the beginning of, this was submitted, it met zoning when it was submitted. There was a lawsuit, it changed, it's coming back as a reasonable accommodation, so we're looking at this site plan, which is,
I do find the
So-
reasonable accommodation piece to be a manipulation of the law, because under FHA, it's housing, under ADA, it's for already constructed
Again,
facilities,
again,
and that
we're
would be
not a-
putting
we're
in
not
a
a court,
handicap
we're
accessible
not a
ramp,
court, we're
not building a new construction.
we're
This
not
is
a-
unheard of. It will have impacts, ramifications across the country. Thank you.
if you want to speak, come up to the microphone. Sure. Frank, you're gonna be last, okay? I'll let you speak.
How many people are gonna be last?
Trying to let everybody have a chance
Mr.
without
Chairman,
staying too late.
the notion
Go ahead.
that the doctrine of reasonable accommodation is available only to renovation of existing buildings is counter to case law. There's a case I sent this morning to my brother, Attorney Silverstein, involving the construction of an assisted living facility which services people with disabilities in New Jersey. Brand new construction, denied by the town, same relief sought. Not allowed by zoning. It didn't apply for a variance or a special permit. It applied for a reasonable accommodation, and the court allowed that. So that's just the way the law is designed to work. If you're allowed to be discriminatory in the written word of your zoning bylaw, and we have to conform with it, there's no such thing as a reasonable accommodation.
Hi, good afternoon. Frank West, 2 Birchwood Road. Couple of comments. One, I'd just like to address through you, Mr. Chairman, what the attorney said, that the town's created a special town meeting specifically to block this particular parcel of land. As you all know, most of you were there at the town meeting, if not all of you, there were many parcels of land that were rezoned that day, of which one of them was his, but there were other parcels of land that Mr. Nealon may or may not even own, I don't know, but again, there was many pieces of land that were rezoned. The other thing that I'd like to say is that y'all keep saying there's a lawsuit out there, and you guys all have to be very careful because there's a lawsuit out there as to what you're saying, because of liability to the town, et cetera, et cetera. My comment is that that lawsuit is generated by the residents of this community, not somebody out in Burlington, Bedford, Springfield, whatever, but the residents of this community. My opinion would be is that I would suggest that you folks delay your vote until that lawsuit's settled, if that can be done, so that any of the results of that lawsuit can be brought open and public before you.
The lawsuit is the vote of the Board of Appeals and them going to court.
So there's no lawsuit with the town, with any residents of the town of Wilmington?
I don't know.
I believe the answer is yes. Council, do you?
The subdivision appeal is by
Appeal.
By a butter. So residents of the community are involved in an active lawsuit that involves this specific property, and as a result, you guys are limited to, potentially limited to conversations or comments you can make. Am I correct in saying that?
I just want to use the microphone since people might be listening at home. So yes, there are two lawsuits right now. There's the subdivision appeal, which was brought by a group of neighbors. And then there is the federal court discrimination case. It is the federal court discrimination case that is making me want to be careful about what I say so as not to increase the odds of a large financial judgment against the town. The residents' appeal of the subdivision approval doesn't carry any monetary damages. So, and frankly, as town council, that is, I have the appearance in the case, in that case, not in the federal court case. As town council, I have been taking what is called a passive role. I'm not actively defending the subdivision approval. I have left it to Mr. Bobrowski to actively defend that approval since it benefits his client. So I'm less concerned, frankly, with the subdivision appeal because if the town loses that case, all that means is that the subdivision approval gets overturned. But if the town loses the federal court case, and I will tell you I was at the mediation, and by law, mediations are confidential, and so I think we can't go into what was or was not discussed in terms of potential land swaps specifically, because by law, anything discussed in mediation is confidential, but I can assure everyone that town staff looked very diligently for that, and that that was a subject of negotiation, but I'm not allowed to talk more about that. But having sat through that mediation, even though I'm not counsel in it, with a federal judge, all I can tell you is that I don't think the federal court would share the view, based on my observations, that the ADA does not apply here.
Okay, thank you.
So I guess there's two lawsuits, one involving the physical town of Wilmington, and there's another lawsuit on direct abutters who have concerns because they have land and livelihood abutting Mr. Nealon's property. If possible, can you folks delay your action until the lawsuits have been settled? You guys can get more information, especially at the federal level. You can get more information and be able to talk, I guess, more freely, if I will, Mr.
No,
Town Council.
you're missing the point of they had the mediation, which brought them back to the reasonable accommodation. That's why we're here, so.
But it's not settled. The matters, the lawsuits are not settled. Am I correct in saying that? Or closed, to use Ms. Sullivan's term?
I guess that's true.
They are closed?
No, they're not.
Right, so they're open, so again, what I'm saying is, until the matters are stamped,
I guess-
closed, and settled.
To get you
is a
away
po-
from the mic, my answer would be no.
Okay, so my comment would be is that, would you be able to settle, wait until these cases are closed?
No,
Why not?
because I just told you, that's the reason why we're back here is because.
We're on a 60-day remand order from the court. First day, I believe, was February 1st, or thereabouts, which means that the request of the judge in issuing the order was that this be wrapped up with a filing at the town clerk's office as to decisions by April 1st. And we intend to stick to that deadline.
Okay, again, I would just,
Asked, answered, thank you.
that's my point.
Okay.
So can I just understand? James Morris, 55 Andover Street.
Okay, James, go ahead.
Can I just understand that the federal court is directing the town to consider whether this is a reasonable accommodation and whether it's grandfathered? I can't tell who is directing whom here.
I don't think that was inaccurate, what you just said. I think
You don't, sorry, you don't think that was inaccurate, or you think it was accurate?
I think it's accurate.
It's accurate, okay. So the planning board is being directed to undertake a decision on this revised plan as a result of some agreement as a result of mediation or some agreement between the town and
Yes.
and the applicant?
Yes.
Okay, all right, well, that,
But the planning board only has one phase of this. The zoning
Zoning
board
board
of
has the
appeals
next phase.
has the second phase of this reasonable accommodation.
okay, so just so I understand the underlying threshold question, there has been no determination that this is in fact satisfying any requirements with respect to whether this is a reasonable accommodation. You are going to decide whether this is a reasonable accommodation because the court and the applicant and the town have not agreed that this is a reasonable accommodation.
The purpose of the remand is to ask both boards, this board and the zoning board of appeals, to make that judgment.
Basically, what
Okay.
we're doing is, we're looking at this as a site plan, okay? And we're saying that as a site plan, we think this is a good site plan, and we're making a recommendation to the Board of Appeals, I guess, to say, as we would anybody that goes before the Board of Appeals, we're asked for our opinion as far as it goes to the site plan, that this is a good site plan. That's all we're making a recommendation.
So it seems to me that there are underlying threshold questions that would be either subsumed in that or would need to be taken up in the first instance before you can decide whether this is a good complying site plan. And at least two of those questions would be, is this a reasonable accommodation, i.e. does the applicant have the right to come here under that provision of the ADA regardless of whether you think the ADA applies or not? And two, is this grandfathered under whatever their previous filing is before you can even decide whether this is an appropriate plan? And I'm trying to figure out, and I think some people asked this earlier, but I think the issue has now been joined to some extent. I'm trying to figure out if you are going to vote on those, what I would consider threshold questions.
Based on our review of the draft plan, our draft decision, we would be.
You would be,
Or-
I guess.
I'm sorry?
So we have a draft
Draft
decision
decision
related to this particular
plan.
site plan. We do this every time we do a site plan review. We have a series of decisions, plans that we reviewed, they're all identified, they're listed. We make that information public before we vote, which will happen here today, if I see that this is the way we always do every site plan. Some of those site plan conditions, they are conditions, because the proponent has asked for things being waived. We do site plan review for subdivisions all the time.
So
The
this,
proponent
Right,
says-
I understand.
this
This
was
is
a
the first, this is,
discussion.
the reason I'm asking,
No,
the reason I'm asking is because this is the.
I want to answer that, though.
Oh, okay, sure.
I guess if this went away as not being a reasonable accommodation, then it would go back to the original site plan. That doesn't go away.
No, it would go back to federal district court.
Court. Oh, assuming he didn't want to go to court, we could go back to the original site plan, right? So,
Okay, and so.
like we
I'm-
said, that didn't get thrown away, it's not like that's thrown in the trash. This has gone to a particular point, they had some mediation, they came to an agreement, it went back, they had some discussions, it went back, so now they're asking for a reasonable accommodation to meet the ADA, so this is the plan they came up with. We think this plan works well as far as a site plan, as far as circulation, traffic, all those things, setbacks.
Thank you, Mr. Chair, that's very helpful, but just so we are
Okay.
clear, are you going to vote, or are you going to consider this site plan?
Yes.
With respect to the present zoning?
Yes.
Okay, that's helpful. This is the first time that I'm aware of that the town, in any capacity, has been asked to make a reasonable accommodation under the ADA for a particular
I've been here 20
project.
years at least, it's my first time.
Okay, right, so it's the first time for all of us, at least, and it's the first time tonight that we're learning that the applicant is even asking for this reasonable accommodation, because we certainly didn't know until this thing came up again. So I just want to be, just so that we understand, I just want to be clear, how do we view the threshold questions, reasonable accommodation and the grandfathered status? Will you be taking separate votes on them, or you're just going to vote on the site plan, and we should assume that that decision
gonna vote on the
would
site plan,
incorporate
and
the threshold questions?
Yes.
Yeah, there are two threshold questions. The underlining use.
And
And the frontage.
frontage.
Those are waivers that they've asked for us to consider. in the
With respect to
reasonable
traditional site plan review?
Correct.
Right, okay, but not with respect to these other larger questions. Because I'm trying to figure out whether, if you approve this plan under present zoning, does that mean that you are saying that you think that this board thinks it's a reasonable accommodation? I just don't know what it is that, I don't know how to interpret that.
I guess that's a good question, and I guess I would say it is, yes.
Okay.
If you're asking my personal opinion, my answer is yes.
Well, I'm just trying to understand.
As we vote,
the
if you have to
process.
vote, the people can speak for themselves. I guess if they vote a certain way, then the answer would be yes. There'd be
Okay.
another way to interpret it, I guess.
Okay, I mean, we just collectively
understand. I
out
like the
here
way
are
you
going to
phrased it.
take that
Thank you
as
very
meaning
much.
it's
That's good.
answering what we
You're
consider
the
to be
last
the
one to
threshold
speak.
question.
Sorry.
Okay.
We got other business to handle tonight.
Thank you, ladies and gentlemen, I appreciate it.
So, take a motion to close the public hearing.
So moved.
All in favor? Public hearing was closed. 4-0. You wanna do that now, or you wanna make everybody wait till 11 o'clock, like they're gonna make me? Okay.
Hot off the presses.
It's full.
So, this is just ready tonight, so that's why no one had it.
You seen it?
No, no one's seen it.
The applicant hasn't seen it?
No.
What red is my face? I don't sweat, I feel like 150 degrees. Lady was right on, I usually advances. I hope. Tries to read my lips. So what are we doing here?
I would read through this and all of that.
I can skip this.
Yeah. That's just the letter portion.
You gave out copies?
I did.
Everybody ready?
No.
Or do you need a few minutes? What's that?
So I think if you go through the findings. Not that part, but the findings. This, I think that would be helpful. Trying to have this ready sooner, but.
All right, the findings. The project site is located at the parcel shown as, says as map 89, parcel 6A. The site plan contains a design that is sufficiently developed to provide the basis for the board's determinations regarding the provisions, requirements, standards, and guidelines of section 6.5 of the Wilmington zoning bylaws and the board site plan review rules and regulations. The development of the site as set forth in the site plan and ancillary materials submitted by the applicant complies with the provisions, requirements, standards, and guidelines of section 6.5 of the Wilmington zoning bylaws and the board site plan review rules and regulations, except that the existing lot does not have sufficient frontage. The proposed project can be accommodated on the existing non-conforming lot, and requiring conformance to current frontage requirements would be a substantial impediment to the use of the property as proposed. The applicant satisfactorily addressed the comments made or submitted by the general public in various town of Wilmington departments, except as contained in specific conditions that follow. The following conditions shall be required at the applicant's sole expense unless otherwise noted. The project shall be constructed and operated in accordance with the site plan. The project shall obtain approval pursuant to and be constructed and operated in accordance with all applicable laws, local, state, federal bylaws, statutes, ordinance, rules, and regulations. If no substantial construction has commenced within 2 years of a site plan approval, the approval shall lapse and a new application, fees, and public hearing will be required, provided that if there is an appeal to the Board of Appeals and/or to the courts, the 2-year period shall run from the date of the final decision on the appeal. The provisions of this conditional approval shall apply to and be binding upon the applicant, its employees, and all successors and assigns an interest or contract. The project shall conform to all existing Massachusetts laws, regulations, applicable codes regarding fire protection and building safety standards. Any revisions shall be submitted to the Director of Planning and Conservation for review. If these are deemed substantial, the applicant must submit revised plans to the Planning Board for approval. During construction work will not start before 7 a.m. and will be completed by 7 p.m. No work is allowed on Sundays and holidays. Construction equipment will not be started before 7 a.m. Following review by the Wilmington Board of Appeals, the applicant must revise the site plan to show all changes, if any, required by the Board of Appeals. The applicant's engineer shall submit a fully compiled, stormwater management report. The Wilmington Fire Department shall review and approve all building plans. The applicant shall receive approval for the proposed septic system. A pre-construction meeting shall be scheduled with the Department of Planning and Conservation and town engineer. The applicant shall submit a construction schedule at the time of the pre-construction conference. If applicable, the stormwater pollution prevention plan shall be submitted prior to the pre-construction meeting. Erosion control shall be installed in accordance with the stormwater management plan and shall be inspected by the Department of Planning and Conservation at least 2 business days prior to the start of construction. Abutting property owners shall be notified in writing at least 7 days prior to the start of construction. The rear property line shall be staked out. As-built plans shall be submitted to the town engineer and director of planning and conservation in the form and format acceptable to them. The applicant shall give reasonable notice to the engineering division for inspection prior to backfilling any proposed underground stormwater management system or installation of any other critical design components. All site work shall be substantially completed in accordance with the approved site plans prior to issuance of a certificate of occupancy. In the event that winter season conditions prohibit final landscaping and/or finished paving course from being installed prior to tenant occupancy, the applicant may post a bond in a form and amount acceptable to the planning board and town engineer, covering the cost of completion. This would be considered on a case-by-case basis. The applicant must have received all other required department sign-offs on occupancy prior to eligibility. Trash pickup on site shall occur during normal business hours. The applicant shall maintain or replace landscaping and fencing as shown on the approved site plan for the duration of the use. The applicant shall use best practices to maintain the required landscaping and fencing in presentable and healthy condition. The applicant shall maintain the project site in a clean and tidy condition, clear of debris and trash. All dumpsters located on the project site shall be enclosed by a fence and be of a side entry design. Dumpsters shall remain closed and enclosures locked. The applicant shall use good housekeeping practices as outlined in the operation and maintenance plan to maintain the site and keep it in good working condition. The applicant shall provide copies of completed maintenance and inspection logs for the construction period and copies of logs of the long-term pollution prevention plan to the Department of Planning and Conservation. The project shall be operated in accordance with the operation and maintenance plan. The operation, maintenance, repair, replacement of all drainage structures, constructed pursuant to the project and located within the site shall be the applicant's responsibility. Snow in excess of the areas provided for snow storage on the site plan is to be removed from the site within 5 days of the snow event. It's 5 days. Snow shall not be pushed into stormwater management areas and drainage structures shall remain clear of snow. Final as-built plans in form and format acceptable to the town engineer shall be submitted to the engineer and director of planning and conservation.
Mr. Chairman, may I add one more?
Sure.
So the discussion tonight was, there was a comment on the snow storage in the front of the property. So the board could consider adding prior to endorsement condition that the plan shall be revised to move the proposed snow storage area located along the front entrance to the rear of the property.
So that should be in.
That would be
the first-
prior to endorsement of the plan, a new number 10, and then we would renumber the rest.
Okay?
There's already one at the rear of the property though, yeah?
Yeah, I guess the idea would be to kind of move that area to the rear to make it larger in the rear.
Okay.
Just along the road, so you're not having to go through a parking space.
Okay. Take a motion to accept the conditions as amended.
So moved.
Second.
All in favor? 4-0. Okay, that does it. Thank you, everybody. Four zip. We all did.
Right here. I voted yes.
We all voted yes. Okay, so we have an 8 o'clock, continued public hearing, definitive subdivision 19-03 and stormwater management permit 19-13 for Jackie Drive, 635 Main Street.
Thank you again. Good evening.
Take a recess.
I guess so.
So,
We're gonna go in order, though.
who, he? So we have a please continue the public hearing to April 7th, 2020, and extend the deadline for planning board definitive subdivision and stormwater management permit to April 30th.
This is for Jackie Drive here?
Yeah.
Okay. So moved.
Second.
Sean, you gotta raise your hand. People are upset.
I raised my hand.
Not high.
I'll go get it.
Okay.
I have to get the schedule book.
Oh. Guess it would be important. So April, what's the first meeting in April? I need a calendar. Never mind, I got a calendar on my phone.
Okay, no meeting without the book. Slap her in the wrist. She came to the meeting without this book. Didn't you do that? Sierra's fault. Sierra's fault. She's the lowest one.
I said to her,
Where do you wanna put them? 635 Main Street, 745?
Yeah, it's,
Okay.
well, it's at 7:30.
79 Nichols, your favorite.
She gonna hand anything in yet?
Not yet. Hey,
Well, it's 8:15. We have 8:15. There yet? Okay, we have a continued public hearing, site plan review, 19-17, stormwater management permit, 19-14, parking release special permit, 20-01, 228 Andover. I'd call you Bob, but then people think we're being too friendly.
That's
Mr.
all right.
Peterson, you're up.
Mr. Chairman, Attorney Robert Peterson, 314 Main Street for the applicant, Arrow Paper. This is a continued public hearing for a site plan request for 228 Andover Street in Wilmington. And there have been changes, Mr. Chairman, to the project from the last time we were here. The revised plans have been submitted. The Pennants, who are the applicants who are here this evening, have actually reduced the size of the building by about 2,000 square feet. They've eliminated the loading docks, if Andy can show us where they were on the prior plan. They've all been eliminated, parking's been put in their place, and the plan is now fully compliant with all of the parking regulations. There are 163 spots provided, where 161 are required, and we have complied with I believe all of the requests that Paul had and given him answers to the comments that he had, with the exception of two, and we are in receipt of his memo relative to the two outstanding items, which we have no issues with. And I'd like to take a minute to thank Paul and Valerie for meeting with us relative to the site. This was not an easy site to work on or with, and Paul's help was instrumental in resolving the drainage issues. And that's about it.
Board good?
Yep, I am.
Yes.
All right, you get 2 attaboys for bringing an easel. Okay, I think we're good. Everybody good? You good?
Is the intent to withdraw the?
Yes,
special
I
permit?
apologize, yes, we're gonna withdraw the application for the relief from parking as well.
Need to close the hearing.
Yep. Take a motion, to close the public hearing.
So moved?
Second.
All in favor?
Would you like a separate letter on the withdrawal?
As long as the board votes on it,
It's fine.
I think that's
Okay.
They're requesting to withdraw their special permit for parking relief because they meet the parking requirement. So that would be a vote of the board whether to accept that request to withdraw.
So moved?
Second.
Good. Withdrawn.
Thank you.
And then
Got
we do
that, Jeff?
have 2 draft decisions, for site plan and for stormwater.
Have you seen them?
We have and we have no comments. We're fine with both decisions.
Take a motion to accept it as drafted.
Anything
So
weird on
moved.
there, Val?
I gave mine.
What do I got here, one of each?
No, it's almost all standard except for the conditions that, we wrote in to address, Paul's outstanding comments, I believe. So the prior to endorsement condition, basically just updating all of the pieces of it and putting it together.
The long-term pollution plan and the maintenance plan,
Correct.
and a full updated stormwater report.
And then, so that's number 8, so that's just, compiling everything that's been updated. And then number 13, Paul had asked that they retain a licensed resident engineer to inspect the excavation and installation of both subsurface stormwater infiltration systems. And if changes to the design are necessary due to the presence of unsuitable subsurface materials or other unforeseen conditions, thinking of ledge or something like that, the applicant or the representative shall notify the Director of Planning and Conservation and the town engineer immediately. The Director of Planning and Conservation will determine if any such changes are substantial enough to require review and approval through the planning board. Those are the 2, kind of conditions specific to this project. And the rest are our standard conditions.
Okay.
Okay, take a motion to accept them as drafted.
Second?
All in favor? You're good.
Thank you very much.
Then we have the stormwater.
They went together.
Oh, they did, okay.
Thank you. Thank you, sir.
All right.
Okay, we have an 8:30 continued public hearing, definitive subdivision 19-04 and stormwater management permit 19-17 for 203 Lowell Street. Oh, they're here. This for the last one? Go ahead, you're up.
I'm Matt Dusenberry from Land Engineering and Environmental Services, representing the applicant, 203 Lowell Street, definitive subdivision known as Veterans Way. Since last meeting, we made a couple changes to the plans. They're mostly drafting changes and labeling. One of the more sufficient changes was towards the end of the cul-de-sac. We reduced the grade from 4% to 3%, as was a condition in the preliminary subdivision decision. It didn't change much to the plan. It added a little bit of grading at the end of the cul-de-sac and raised some drainage structures. Other than that, we had to increase the drainage easements to 30-foot wide to comply with the subdivision regulations. And the remainder of the changes were, like I mentioned earlier, labeling and drafting changes mostly. I believe we met all the comments from the town boards, and that's where we're at now.
No, the only thing, you know, they asked for one waiver on the, locating all the trees on the plan, which we said was okay. Right? So we're good? Good? So, we can close the public hearing.
So moved.
Second.
All in favor? Oh. Fall off my chair. Few people who would like to see that, I think. There you go, that goes back to you. All right, so what's this? This is,
Draft decisions.
one's stormwater?
One's stormwater and one's a definitive subdivision approval.
This is the stone.
You guys have this? You have a bunch of extras? Sorry.
One's the site plan decision, the other's the stormwater
Right.
management.
All right, you wanna go over these?
Well, I mean, it's in here somewhere.
Have you seen these, Jackie?
We did, yep.
You have any questions?
Nope, and I sent it to Mr. Yetman, and I didn't get any questions either, so.
Trying to
Want me
behave.
to
Go ahead.
comment on what's out, what's,
Well, I just wanted to
Conditions.
comment that, you know, this is standard procedure. Go ahead.
oh. So, let me see. The conditions that were specifically drafted for this, to kind of cover all of the outstanding comments, prior to endorsement number 17, a full stormwater report inclusive of the supplemental information dated February 10th shall be submitted. Again, that's just compiling everything that was submitted into one report. And then we did, number 19, number 20, and 21 have to do with the easements, along Lowell Street, for the proposed roadway improvements, and, one for the right-of-way and one for, the utilities, and then also for the drain easement, along Woburn Street frontage. Those conditions.
Verizon.
Right, so, right, other than that, they are standard conditions for a subdivision.
What's NPDES?
So that's the, let me look at it so I make sure I get all the words. Non-point discharge,
Like a Mass DEP permit?
help me.
Yeah,
Where are you?
what it's.
I'm sorry.
Number
Nifty's.
22.
NIPD's,
is-
National Pollution
Yeah,
Discharge,
the DEP permit.
Environmental Service Boards. Do them all the time.
So it's Mass DEP, their water, like the stormwater
Stormwater
pollution prevention
pollution.
plan,
Yeah,
all that stuff.
yeah.
Okay,
Yeah.
got it. I just never seen.
It's a discharge permit when you're doing the construction.
I think it's EPA, right, EPA?
Mass DEP.
No, it's handled by
required.
local
Okay.
DEP.
I learned something new today. And then you list the one waiver request.
It's at the end.
Waivers, okay, got it. See.
Good. Stormwater ones are good? Take a motion to accept the conditions as drafted.
So moved.
Second.
For both.
Good. You're good.
Thank you.
Thank you.
Nice to see that lot, real property.
Matt, so are you here for 168 Lowell Street later too? Yes. Okay, we won't be able to hear that application tonight because we took down one of our members. So we did prepare a request to continue that hearing,
Which one's that?
168 Lowell Street. So for that application, Sean recuses himself. And so we would need Angela here to make the fourth person for the special permit.
So we're not gonna do that one.
No, we can't.
So are you here for 168 Lowell Street, anybody? No? Good.
Where is 168 Lowell Street? This one? Oh, Joe Lingo. As far as Angela, did she, would have been taking on it because Joe staying, Jennifer was
Should we just vote on to continue that one now, or do it later?
No, we can't.
Do it in order.
It says gotta do it in order. Okay, we have a continued public hearing, site plan review 20-02 and stormwater management permit 20-02 for 330 Ballardville Street. Okay, you're up.
Okay, so I'm Edward O'Connor, the contractor for Monogram Foods. The owners of Monogram Foods have joined us this evening. John Judd, professional engineer. We're here to basically resubmit the industrial loading dock addition that we proposed at the Monogram facility. It's a bakery which receives bread, and it's looking for a place to add a couple of loading docks onto a paved surface. We developed a improved or an enhanced site plan to show drainage and also some other parking requested information. And that was all somewhat scattered throughout the drawing set, and now it's been addressed and depicted on John's plans.
So. This is, so what do I got here? This is the stormwater permit here. Have you seen these comments by the town engineer?
What's the date on those?
This says March 2nd.
Yes, we addressed those in a letter to the
This
engineer.
March 9th here.
Yes. Well, that, I believe, the March 9th response is to Valerie's comments, and we had a previous submittal last week, which was March 5th.
So which one did Paul review? It says here, reference material, February 25th. Stormwater management report, site plan 2 sheets, February 25th. The applicant's engineer submitted stormwater management report for the proposed conditions analyzed in the 100-year storm event. The report addressed compliance with some of the standards of the Department of Environmental Protection, stormwater policy. However, we note the following items that need to be addressed. Provide documentation to demonstrate compliance with DEP policy standard number 3 for recharge volume using impervious area, post-condition, and for the town's local comprehensive stormwater bylaw and regulations, which requires 150% of the state's policy required recharge volume.
Yes, so again, we addressed that on the 5th to the letter through to Valerie, and I copied Bill Holt on that as well as Paul, addressing those items which were included in the March 5th report. Point by point, there were 4 points that were addressed. The recharge volume calculations have been revised as requested. The second item, the water quality volume calculations have included a 1-inch depth in those calculations. And then they had asked for, the engineers had asked for the 210 as well as the 100-year event. We had modeled the drainage for the 100-year, and they wanted the 2 and 10 as well, so that was included. And they had asked that we modify the storage calculations for the subsurface structure. We're not modifying that at all. That's a pre-existing structure. And they just recommended that we take another 6 inches of credit for the volume because those are 42-inch pipes. In the model, we originally only used the 36-inch depth. So I believe those have all been addressed, and
So those have been addressed since then, but Paul hasn't seen them.
Right. So Paul hasn't reviewed those new plans that came in yet, because they came in, I believe it was last week and then today.
But there's nothing really on the plans that's a problem. Those are all stormwater things, right?
Stormwater things and then plan things on this.
So, okay. So that took care of that. So we chatted. The left side of the building setback should be shown in the plan and confirmed in the zoning chart. Took
yes,
care of that?
so that's been added right here, and as well as in the zoning chart.
Proposed condition plan should clearly show the proposed condition in respect to the elimination of the parking of the proposed building, adding loading areas.
Yes, so we added a note here that there are 10 spaces proposed to be removed here, as well as adding the 2 loading spaces here at the end of the proposed addition.
Okay. The plan should provide the total area of each use within the building for the parking requirement calculations. The floor plan should be submitted.
Yeah, those have been added right here in the parking requirements, which include the office space within the building, the industrial space, as well as the addition.
The number of parking spaces in each row.
Those have been added. We've enumerated those with descriptions on each row, so that has been added to the plan.
Truck parking and loading should not be used to satisfy the parking requirement. The parking calculation should be revised.
We took care of that as well in the chart. So we eliminated, we took no credit for all the truck parking and loading that's currently on the site. There's quite a bit.
The plan should indicate how many accessible parking spaces are required, and those spaces should be shown on the plan.
Yes, as required by ADA, we've added those right here, close to the entrance of the building. 4 spaces are required.
So you answered all these questions, but the problem is no one's seen them.
Right, because our plan doesn't have what you've got there. The plan that we got. This one says 225 on my side.
Right, so we
Right, so that, the revised plan came in today, so we haven't had time to look at it.
So what we can do is draft a decision,
For
and
next
close
time.
the hearing next time and vote on the decision.
Next time we could close the hearing and
All right,
issue a
so
decision.
how confident are you gonna get Nichols at 7:30?
Well, they're gonna do something. We can do, like an 8 o'clock though. Can we do 7:40?
Yeah, do that.
Okay. Sure. This will be quick.
All right,
7:30.
all right,
We need to change the action deadline and
yeah. So we're gonna put you on the agenda for next time at 7:40, and it'll whiz through, just ask for an extension.
Can I ask one question before?
Yeah, go ahead.
So one question, just, could you point out, one of the comments was showing the areas that were used for the 5% parking lot landscaping requirement?
Yes, so what we did, Valerie, we shaded these areas here for the interior 5%. So we have this area right here, which is, we showed that here in the legend, proposed landscape area per section 6.425. So this area right here, and this area right here are what we used in the 5% calculation. So that's the actual area that is provided, and we show the total area of the parking is 152.4, so that's in the chart, 152,000 square feet of total parking, and then we took credit for this as the 5%.
Okay, so typically we see, those islands that are actually within the parking, the main parking area. So the 40, I think it's over 40 spaces required, trips
Yes.
the requirement for the 5%. So that's why you would do those landscape islands on the ends of those parking rows. So it's interior landscaping, to that parking area. So it's up to the board whether those areas in the loading zones would count towards the interior parking requirement, landscaping parking
Looks
requirement.
like he has one on each end.
Well, these are, by the nature of the business.
Striped?
Yes, it's gonna, exactly, striped, and the nature, in the applicants here as well, but the nature of this business is the large trucks coming in, making deliveries, the turning radiuses and so forth.
So what he does.
So that's why we'd like to
How
take,
much off is he in the 5%?
we'd like to take credit for these areas here, which are, it's still on the interior of the parking area, but not necessarily the conventional islands that you'd see in an office park. This is more of an industrial use with the large trucks taking deliveries.
Is there a reason why those islands, closer to Ballard Vale at the end of the parking rows were not used? So there's some, exactly.
Right here. Yeah, they would add an additional credit, but it wouldn't suffice for the total 5%.
Because I suspect that the islands at the other end were part of that the landscaping requirement, and those are gonna be, removed. So I guess if there's a way to incorporate that landscaping back into that parking area.
This right here.
I think that's more the intent of the bylaw.
Again, it's, you know, with the nature of these trucks making these deliveries, the turning movements coming out of here, what happens is the trucks end up going over those islands. So, you know, we respectfully request to be able to use these areas as well as this. That would be maintained.
It's just down the end, she wants it flat,
Right.
just striped.
So there's also a leased space that's unpaved, which is being used for parking. And it was all green space. It's a long-term lease, which is gonna be purchased by Monogram. So that's actually on the, it's not shown on the plan, but it's being used by, if you went there, you would think that it was part of the plan. So that was all grass with just a gravel, a temporary gravel parking lot on it. I don't know if that's part of the calculations, but.
I'm gonna give a vote.
Because it's a big, I mean, I know it's, obviously it's a respectful request, but it's a big part of their plan to be able to make these sandwiches and to continue to operate, and it's gonna be a hardship to wait this period of time, because really, a lot of what we've had since they bought the building, and they've inherited that. So, you know, I understand there's a process, but we just got this letter on Friday, so it was only a day and a half to react to it. So we're just looking for a little kind of, any type of work that we could do to get going on the project.
We don't have any conditions driven up, right?
No, and I guess one other question for the board is, typically we like to see lighting on the plan, unless you're okay with not seeing the lighting on the plan. I imagine there's building mounted lighting out there.
There is, and we've attached, that was.
I attached it today, again, I just got the request Friday, so these are all lights that have been there since the client bought the building. It's a well-lit industrial facility. We're just we're not adding any light, we're relocating 2 lights for the small orange addition.
And then if I could make one more suggestion, where you have that addition colored in.
Yes.
Would it be possible to just show the proposed condition? Right now, there's kind of parking underneath that where the
Okay,
addition.
eliminate the parking?
I think you should show what's just being proposed.
Sure.
So it would be wiping out that parking under the addition and next to it, and just showing a completely proposed condition out there, so that inlay of pavement would also go away. It would just, you know, it would be.
Right here?
Right,
Okay.
right.
No stripes.
Yep. Would this be okay here, Valerie, this section?
Yeah, I think that's a proposed condition.
Correct.
Do we have to endorse these plans? I mean, because if they're.
Well, we're not gonna, he's gonna have to come back, because we don't have the.
So a lot of this is also on the architectural plans, which have never really seemed to have been looked at too closely, because we're focusing on the site plans.
That's pretty much what we do. I mean, your addition's gonna be compatible to the existing building, so.
Right.
It's gonna be block, maybe split face block.
We can easily take care of Valerie's request.
What I was saying was that we could close the hearing and endorse the plans next time.
But then they can't make changes to the plans. if we close the hearing.
Not tonight, no, what I'm saying is
Next
next
time.
time, since,
Yeah, we can
They-
do all three at once if it's possible.
yeah, I would think so.
Mhm.
Because it's just a couple things that our engineer has to just be happy with what you've done.
And then the zoning chart was updated, I think it was, those numbers were from the previous plan, the previously approved plan.
These are all current, these are.
Okay, good.
Yeah,
Okay.
these are the revised ones based on my letter to you.
Great.
That I emailed over and dropped off as well.
All right, so we'll put you on for 7:40 on April 7th. You need an extension. We'll whack out everything in once.
We love to ask a question.
Sure.
Is there anything we can do to get some type of partial start of this project? We have some very large customers like Starbucks and Kraft, and we are truly struggling to meet their demands. April 7th is going to put an extreme hardship on our business, not having stock, so we can temper bread to keep the supply going for our customers, which puts us at risk of losing the customer because in our contract with them, they state that we cannot not meet their demand. I've been working with Ed for quite a while on this. I just am asking if there's anything we can do to keep our business moving forward. I'm from Memphis. I'm the Chief Operations Strategy Officer for Monogram. We're basically here begging to get this thing started so we can meet our demand come mid-April. 7th is going to put us in a lunch room and risk of losing business and quite possibly some of our employees if we do start the business.
How's
We
your
have worked in this community for a long time. We've spent a lot of money. We've hired 500+ people. We understand the process. I'm not arguing that at all. I'm asking for some type of conditional agreement to go. I guess if I have to and he doesn't approve it at this next meeting, I'll fill the hole in and cover it up. If you want me to put that in writing, I'll do it.
No, we'll, I mean, there's really not anything we
Because
can
we
do.
will meet any demands that you have that are anywhere near reasonable, which I believe they all are. It's just we are in a tight spot with our customer, and I don't want to have to go back to Memphis and tell them that, once again, we're going to be 2 weeks later on completeness. I mean, Ed has got a plan to use crews pretty much 24 hours a day. It's going to take us about 4 weeks to complete this work, maybe 5.
Yeah, but you can't do anything till you get a permit. You're not gonna, you can't get a building permit until we sign the plans. So we don't have any plans to sign, so.
So you don't have any at-risk permits in the
No.
town? Okay,
Not to my knowledge.
Not through this board, no.
okay.
So, I mean, next meeting you come, we'll approve it, and we'll sign all plans.
Where's the
And then you
existing
can,
loading dock now?
walk out of here.
There's several.
Because the addition that you're putting on is very small.
It is.
1,250, it's 1,257 feet or something like that.
Frustrating.
It's just like putting a garage on.
Well, yeah, so
1,200
I'm
square feet.
just wondering if you can't just load through your 2 or 3 different docks.
It's about tempering the bread, so the building inside there is gonna hold 72 pallets of bread on racks.
The little addition that you
It
put
has to
in.
go from frozen to 40 degrees so we can still make the Starbucks sandwiches.
The rest of the building's at 35. So the problem is the building they bought had 3 receiving docks and 5 shipping docks. So we're just balancing the table.
Is what it is. So, take a motion to, continue the public hearing, 7:40 and April 7th, and the action deadline to April 30th, 2020.
Someone,
Second.
See you then.
and if he gets his plans in, we can do everything in one shot. It'll be able to permit by that Friday, right?
Right.
Thank you.
Yep. So what do we got here now in, 168 Lowell?
I'm gonna continue.
One 68 Lowell, we have a continued public hearing for 168 Lowell, multifamily special permit. Please continue the public hearing to April 7th, 2020, and extend the deadline for planning board action, site plan review, and stormwater management permit 20-01 for 168 Lowell Street till April 30th. Joseph Flangone, the applicant. Take motion to extend to 8 o'clock on April 7th, and the deadline till April 30th, 2020.
So moved.
Second.
Favor? Sean, raise your hand.
Sean doesn't vote. Sean
Oh,
doesn't
that's
vote.
right, Sean stays. What do you want to do next?
Sorry to disrupt your night.
You've got A&Rs and you've got ZBAs.
Let's do the ZBAs.
First one is for 9 Cushing Drive. They're proposing an in-ground pool and a shed. They meet all the zoning setbacks, but they are in the groundwater protection districts, so they propose a system to mitigate the extra impervious area. I believe Paul is okay with it, he's seen this.
Which one we on, I'm sorry?
9 Cushing Drive.
Paul Sini said he was good?
Good, right?
All right. Reapprove.
I concur.
What's the next one?
The next one is the 4th of July.
Carnival?
Here we go.
I don't have a problem with it.
Yeah, it's very similar to last year.
We approve the carnival. We're mean, but we're not that mean.
Right. Okay.
What's that?
Got A&Rs and plans to sign.
We have plans to sign?
Just one, that's it. Just one page.
One page, oh, I like that.
11 Forest?
Maybe it's 2.
Do we have to do any action on the letter that you got about appealing 11
No.
Forest?
Nope. That
Again,
was just an FYI.
I've gone by there.
So the A&Rs?
I believe the plans for 11 Forest Street are being distributed for signature. They met all of their prior to endorsement conditions.
Okay.
All right, what do we got on the Form As while he's doing that? So what's this Micklin Road?
I guess they're giving a little bit of land from one of their parcels to somebody else. How much I know.
That's right.
Do you have it?
Yeah.
Yeah, I was gonna say, it's not in here, so. Keep them closer to
Yeah, I don't think we get A&Rs electronically. Someday.
I am
Yeah,
out
not
of
yet,
this.
but it's,
2,000 messages on this. I can't stand this. It's like junk.
you're up against the microphone, please.
Wakes up the people at home.
So what are we doing here?
So the purpose of this is to take a piece of lot, which one is it? 12A, and convey it to, let me just make sure I have this right.
To the,
So they want to have 2 buildable lots?
So they're taking
that little
this
triangle.
little piece right here, so it's this long skinny and this piece right here, away from,
Them, so they can.
From this one.
lot, So they can have 40 feet
They had the 40 feet here. This is just making it a little bit wider and a little bit more a little bit extra room. This is Ken Chisholm's house, so he's just kind of squaring this off to give his lot a little bit more area. So this is a non-buildable lot, and it's just being conveyed from here to here.
What's the zoning?
That's the existing lot, creating a new,
They're creating,
Are they
so they
both
create the
R20s?
non-buildable to convey it. Yes, it's R20. So this is a hammerhead lot, and this is a regular lot.
But they have to convey it to make that a buildable lot, don't they?
They don't. They're both buildable lots already, right now.
Really?
Yep, so they're just taking a little bit of the excess of 12A and conveying it to 13A.
Oh, I thought they needed 40 feet, so they need that little strip.
No,
of
you
paper,
had the
40 feet.
circle already.
They had the 40 already.
So they just want 45, huh?
Sure, why not?
It's a
It's
little
just,
less.
just a little bit of shuffling of the area around.
All right, take a motion to accept the Form A as submitted.
And that is for 16 Mayfair.
All in favor? What's the other Form A?
Mayfair left-hand. It's all right. Oops.
It's okay.
These go with that one.
Is that all it is?
There's 2 pages.
2 sheets?
Ronnie, one
No,
page.
that goes with.
One pages.
This is Kelly Road, 7 Kelly, new construction. They're taking a back corner of the lot, non-buildable lot, and they're conveying it to the adjacent lot that's already built on. So again, it's a similar situation where you're having one lot that's buildable, convey a piece of their lot to another lot that's buildable. So, so the purpose of it, we've been told, is that this parcel over here, they have a hard time getting around the back of their property here. So that little bit of extra room would give them a little bit more maneuverability. But essentially, you're having a,
Is there any sort of requirement that the plan shows that other piece of land, that other parcel?
not specifically, you could show that, but where it's a non-buildable piece going from one built to
Yeah,
another
I mean,
built.
I get it, I just asking the question because I haven't seen one that didn't show it before. I don't think. All right. There's no rule, there's no rule.
Okay, take a motion to accept the Form A as submitted.
So moved.
Second.
All in favor, say aye.
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 Should've hired the engineer right away.
Give me an architectural plan for myself.
That's what we were just looking at, so.
Nobody did.
We only have one Sharpie today.
Sean's got
You got one? You got two.
There we go. You can pass me that Sharpie when you're done there, Michael.
so we'll see you all next week for the joint public hearing?
Yes, ma'am.
From the engineer.
It's the old Charles Lafayette used to say, "Creek don't run, there ain't no boat down." I guess I'll do it.
Do we have one of those for the other one? This is,
Yeah.
I don't remember the paper ones for the other one. The other form.
Kansas State
Cheryl,
Kansas State.
did Rondi sign those paper ones?
Yes.
Okay.
Is this what came over at like 3:45 or so?
Yeah.
So Ronnie called and went,
So is this meeting adjourned?
No, we got something else to discuss. What do we got? This is done, that's done, that's done.
did we have paper
Well, now we
copies
gotta
of
do
the Mink Run Road?
Yes, right here. Right
You
there.
signed it.
That's 70,
That's Kelly. Sorry, this is Kelly and that's Kelly. I just asked her if you signed Mink Run and you did.
You did.
Oh, okay. Oh, so we only have one set of endorsements. Okay, got it. Never mind. I remember signing it.
Meeting is adjourned.
Okay, thank you.
Thank you.